situations, if I were elected official, I would either want to dump everything on a hearing examiner that I possibly could and then leave me out of it, then I can go, great, I can talk to my constituents about this because it's not coming before me, and I don't have to deal with it, and I don't have to risk personal liability or an appearance of fairness disclosure. So again, one of the reasons.
Except that oftentimes the appeal from a hearing examiner is example.
It shouldn't be. Sorry. It shouldn't be. My recommendation, yes, that's true. Some cities do that. I haven't looked at your code specifically. It shouldn't be.
I know she shot a look at Bob on that one. That's not like the staff made a mistake. That's the council's call on how.
No, I didn't. No, it wasn't.
Yeah. Well, no, I just want to clarify the council's call can determine how they want that appeal process to on all those issues that you talked about.
Yeah, I'm not here to tell you how to revamp your code or what jurisdiction to give your hearing examiner or not. That's not my place, and I would be remiss to. I'm telling you from a third-party, outside, risk management, how to do it right kind of case, the best use of a hearing, and I'm going to talk about hearing examiner in just a couple of minutes. I keep saying it, but one of the things I'm going to tell you is use the hearing examiner as the final decision maker whose decision should be appealable to court from that point, not to the council. And no offense, this is not an indictment on the council at all. I hear this all the time. The whole idea is to remove the council from the decision-making process, whether it's in a open record hearing process or the closed record appeal process. Take yourself out of it, defer it to the professional hearing examiner, and I'll explain why in just a minute, if you can. But again, that's a legislative decision, how you set up your hearing examiner. All right. Yes, sir. Yes.
Mike, this is for a council and planning commission, so perhaps this question is for a different seminar, but mayor's in a different position on these kind of conversations with citizens and developers and so forth, and quasi-judicial. A lot more freedom because I'm not a decision maker. I don't make a decision at the end of the day. I mean, with that said, there still has to be some caution because, as all the staff serving at the pleasure of the mayor, you can still have those appearance of fairness issues. But I don't know if you want to spend a minute talking to that or with the.
Well, okay, so that's a good point, and I take it, and I haven't looked to see how you're set up. Are you a tiebreaker in any instance? Could you be a tiebreaker?
Could be if the decision were adopted by resolution rather than ordinance.
Okay, what about like on a final plat or some other like if there's not quorum, would you be a tiebreaker, for example, or would you have any decision-making role under any circumstance in a quasi-judicial matter?
Potentially.
Yeah, potentially could be. I don't recall it's ever happened in history of the city, but.
Yeah. So, and again, I don't want to second guess how you got everything set up over here, but my suggestion as an outside speaker here would be that you consider yourself part of the quasi-judicial decision-making body and try to follow the same rules. You might have a good case to say I shouldn't be bound by that, and it might, my point is I don't think you want to go to court to test the scope of your decision-making or not. And I would kind of urge maybe that you just consider. And I guess the other problem is there's a potential, I don't know if I'd say appearance of fairness, but there's a potential issue with somebody could make a claim saying, well, gee, the mayor isn't voting on this, but he's been talking to all the council members, and we know how he thinks with respect to, pick your poison, Walmart, a new gas station, a Starbucks, a whatever, affordable housing, whatever it might be, that you are potentially, again, potential claim, improperly influencing the actual decision makers because of your status as mayor, and you meet and confer. I'm throwing this out. Lawyers are notoriously conservative in trying to identify potential risk areas, and I think that's a possible risk area. I would probably defer to your esteemed city attorney on that point and get some feedback from Bob on how he thinks would be best. Since those are my off-the-cuff, unplanned comments. All right. Yes.
Sorry, one more thing. Backing up to your comments about statements made as candidates or while campaigning. And just to note, to take us out of Snoqualmie for a moment, if you want a good example of how campaign statements can come back to bite you, just read the Ninth Circuit decision or the Fourth Circuit decision in the president's travel ban cases. And those are not land use decisions, but they're good examples of how in today's day and age, things made on social media, television to newspaper, the person in the grocery store checkout line whose aunt writes a blog or fill in the blank. Those statements, don't just disappear into the ether.
That's a great analogy. Great analogy. Yeah, keep that in mind. All right. So let me zip through this real quick. You guys are asking great questions. This is kind of the focus of what we're talking about. Quasi-judicial decisions, again, need to support them with substantial evidence. There's actual definition of substantial evidence. And I'm mentioning this to you because, again, if you're the decision maker on a plan, a site plan, one of these quasi-judicial applications, this is your obligation. You can't just go, well, there's evidence in the record, it's okay. No, the standard is by law that it's got to be substantial evidence, okay? Substantial, and there must be sufficient quantity of evidence in the record to persuade a reasonable person that the declared premise is true, okay? That's a lawyer definition, but it means you can't just make up evidence. There's got to be an amount of evidence, a quantity of evidence that would persuade somebody that this statement, this fact, is actually a true fact and not just something made up. That's what a judge is bound by. That's what you folks are bound by. You got to support the decision with findings of fact, and I'm going to talk about those in just a minute. Very, very important. I will tell you from my experience that on a land use decision, if it's challenged and goes to court, the first thing judges look at when they're reviewing the decision, well, second thing, the first thing is what's the decision? Approve, deny, condition, what is it? But the second thing, and probably more important than that, are the findings of fact. They're looking to see, A, do they exist? Yes or no. If they don't, you've been arbitrary and capricious, decision's invalid, it goes away, null and void. If there are findings, are there sufficient numbers of findings, and are they done in the right form, and do they support and explain the decision? I'll go through those in just a second. Also with quasi-judicial, you can't change standards mid-process, okay? So part of the way through a development process, and particularly one that's done, for example, in phases, phase 1, phase 2, phase 3, or development agreements, or developments that are governed by a development agreement, that agreement or the overall process that's set forth in your code governs the application, start to finish. And if you violate that, you are here we go. Violated the vested rights doctrine, regulatory reforms, a whole series of statutes under RCW 3670B, and arbitrary and capricious standards. And this is a quote from one of those standards: fundamental land use planning choices made in adopted comprehensive plans and development regulations shall, that's mandatory, serve as the foundation for project review. That means that's the rules you follow when you're reviewing the application, okay? All right, let me zip through some other things. This will probably further frustrate the elected officials, and I apologize, but it's just the way it is. The city on a quasi-judicial application is not representing anybody. We're not there to represent the developer or the property owner or the applicant or citizens or neighbors. And I'm sorry, but that's the law. The city is a neutral, independent decision maker. And again, I analogize this to a trial court judge. If you go into a trial before Judge Smith, and Judge Smith is there advocating before the trial starts on behalf of the plaintiff, the person suing, and talking about his friendship and relationship, and, well, I'm going to give you every break I can, Mr. Plaintiff, would you think you're getting a fair trial? Of course you wouldn't. You go, this is tainted from it's the exact same standard here. So, with all due respect, and all those folks sitting in the audience here, the city isn't your attorney and isn't your advocate. I'm sorry, on a contested application. Different for legislation. Then you can talk to the city, push, all your goals and policies. That's what it's there for, but not a quasi-judicial application. I put this comment up here. Citizens ask, well, who represents the people? And unfortunately, it's not the city, but they can go out and get their own attorney and advocate on their behalf. But I see this all the time with citizens, even developers come in, and they'll come to me when I'm representing a city on a matter, and they'll go, well, Mike, I want you to go talk to the city council members and tell them why they got to approve it. And I go, absolutely not. Absolutely not. And I frequently send emails back saying, don't ever communicate with me again on this. I can't do it. I am acting as an attorney for the city decision maker. They're an independent body. We don't represent anybody. It's the same thing whether you're talking about the landowner, the applicant, citizens, whatever. And it's just, I'm sorry, that's the way the process is. Decision making.
Talk to the applicant about a different lawyer.
Yeah, exactly. Well, and the problem is a lot of people want to come in and they want to get involved in these, again, quasi-judicial decisions. They don't want to go out and spend money for a lawyer, and maybe they don't know a lawyer and that, and I get it. But the problem is that they can't go to Bob Sturbank or go to the mayor or go to somebody on the council and say, we need you to advocate for our interests on this mill site project or the Walmart project or whatever it is, because that's not taking an independent stance, and it's just a recipe for a disaster. I already mentioned, we'll talk about the appearance of fairness. That's what AOF is. Misspell there, AOR, but AOF. Adopted standards, decision can't be arbitrary and capricious. If a decision is found to be arbitrary and capricious, quasi-judicial decision that is, it's void, city loses, city may have to pay big dollars. And I'm going to talk about arbitrary and capricious in just a slide or two. Real quickly, I think I've talked about a lot of these already, but this is kind of the summary for quasi-judicial. Follow your code. No policy making, visioning, or city goals. Okay, sorry, pounded on that, but it's the law. Recognize and enforce vested rights. Consider all the evidence. Okay, so I've been involved in cases on, for example, plat applications where decision makers on the record will say, and it's usually like a city council or something, saying, well, you know what, I don't like this developer, so I didn't read his expert's traffic report, but I read the one submitted by the neighbors, and I like it. You can't do that. You can give different weight to the evidence that's submitted by the parties, but you've got to consider it. And again, no different than a judge going, I'm ready to rule, but I want to let you know that I didn't read the plaintiff's opening trial brief. I didn't think it was necessary, but I read the defendants, and I'm ready to rule. You think you're getting a fair trial? Same thing. Yes.
So, in a true judge situation, the ones that I get paid big bucks, they issue a written statement explaining their ruling. It's not just say, yep, see ya, there's a written ruling. We don't do that, right? We may not even disclose in a public hearing what's going through our head. We may not ask, we may just process that inside our head, and then we say yay or nay. So it sounds to me like, unless you talk a lot, which I do, no one would know what evidence you use to make your determination, because you didn't say anything you have to write with it. You just voted yes or no.
Okay, let me correct you on that. I hope that's not what's happening on quasi-judicial decisions. If it is, you need to change that, because you actually do have to do just what a judge does. You can't just kind of hide what's going through the decision-making process. You need to disclose that in writing through A, the written decision, and B, findings of fact and conclusions of law, which are written, which support that decision. If you're not doing that for quasi-judicial decisions, you got a problem. And I would urge that, I'm assuming that doesn't really happen, but
It happens.
well, all right, so my advice at this point is, don't let that happen. Make sure, and you're gonna see, hold on just a second, let me zip this.
Mike, if I can just jump in, the council has, for all of the quasi-judicial land use decisions, adopted resolutions that themselves in turn adopt findings of fact or conclusions of law. Often they adopt by reference the planning commission's findings and conclusions. The one exception being the most recent, where the council came to a different decision than the planning commission and therefore adopted their own findings and conclusions. And if anybody in the audience wants to go back and look at those, they'll find those attached as an exhibit to the council's resolutions. And all the resolutions on the Ridge 2 and Ridge 1 have findings and conclusions.
Perfect.
But
All right.
it's true that most decisions that the council makes are on a motion and generally oral and then just memorialized in the minutes. Those types of things are typically legislative and not quasi-judicial language.
Right, and to follow up, and Bob, look at you, on that point, that's very crucial. It is absolutely lawful and absolutely proper for city council acting in a quasi-judicial capacity to approve and adopt by reference findings of fact prepared by either staff, the planning commission, or some lower entity within the city, and reference those through a resolution or in its decision. Absolutely proper, and it's done all the time. So as long as there's something in the record to show the findings that support the decision, whether they were originally made by staff, which are just adopted by reference, or separately enunciated or added on to, that's all fine. It's just at some point, the reviewing court, and this goes to your point, a reviewing court on an appeal, that's the first thing they're gonna look for. They go, we wanna know what was going on in the minds of the city council when they approved or rejected this project. And the response to that is, well, okay, they adopted by reference the findings of fact submitted by staff as part of its staff report, and those are their findings. Perfect. That's lawful, that's proper, and that's done all the time. So,
What
I'm
is
sorry.
the reference?
Yes, sir.
No, thank you, that was where I wanted to go. I didn't want Sean thinking that he was obligated to draft his own.
No, and it comes as a group. No.
Yeah, and so, and to that point, we have always done that contrary to a comment that was made, so.
I appreciate that, and I kind of surmised as much knowing that you got a pretty sophisticated group here. I just didn't think that was gonna happen. So anyway, all right, well, great, yes. Oh, I'm sorry.
When I'm sitting in the role of a judge, and I'm taking evidence from the applicant's attorney who explains what's right, who influenced me on making the decision. And if the citizens have an attorney, and their attorney is advocating what the law is, what is the role of my city attorney?
Okay, so, your city attorney, I think, can advise you on what the law is or the standards to be applied if there's a dispute over that. To be honest with you, in most cases, quasi-judicial cases, there should not be a dispute over what the law or the standards are, because presumably, and again, this isn't gonna happen every time, but most of the time, you should be able to go to your code and say, okay, we got a conditional use permit application in front of us, let's go to section 17 point blah, 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 the Snoqualmie Municipal Code, and look up conditional use permits, process and criteria, go to section 040, and it's gonna list the 12 criteria. That's the law. And so if another attorney's standing up there saying, you know, well, there's different standards, or you need to consider this, hopefully that shouldn't be an issue, because the law should be as presented in your code. If there's a conflict, if it's vague, if it's confusing, I think that's appropriate to ask your city attorney to explain that. And if it looks like it's an issue that's potentially risk infusing or potentially could lead to litigation, you can ask for an executive session and discuss it with Bob in confidence there if it looks like it's illegal litigation. But that's what your city attorney's there for, and you should be able to ferret those things out. Any other, you want to say, okay, I mean, that's where I would go. And what I wouldn't do is just guess and go, well, gee, the neighbor's attorney says the law is this, the applicant's attorney is saying it's something completely different, and we gotta comply with this standard, and staff members said the standards are this, and it's a third thing, we don't know what law we should be applying, what criteria. That's an important situation where I would either ask the city attorney on the record for assistance and let the city attorney decide, this is something I can advise you on openly, or this is something that could lead to litigation because they're threatening litigation or whatever, and decide how to advise you. But I would ask for it. I wouldn't just go, well, let's flip a coin here and pick this one, or do a hybrid. You don't want to do that, because that's just ripe for mistake. Okay? So it's a good question, great question. All right. It is, and eventually I'm getting to that. You guys are just asking great questions, and I get it. So real quickly, a couple of just big rules here. This is, man, I don't know how many times I've had to defend lawsuits where cities and particularly elected officials want to get involved in and help adjudicate homeowner disputes, CC&R disputes. I'm dealing with one right now. It's driving me crazy, and it's probably going to lead to a lawsuit because the city, you know, it's no good deed goes unpunished. These are private agreements. Cities should stay out of them. And again, I know there's, you know, elected officials are going, wait a minute, you know, my constituents want me to help out with these kinds of things. You shouldn't. They're private property agreements. The city should not be involved in them. The city's role is as an independent, neutral body adjudicating contested applications and shouldn't be involved in these kinds of private disputes, okay? And, you know, I'm going to emphasize this. We're going to talk about it in just a second. Oops, back up here. Okay, and this is the next slide. Always end up with good written findings and conclusions. Again, as I mentioned, I'm going to add this to my next presentation to say you can certainly adopt by reference those findings and conclusions of the staff or planning commission or other advisory bodies. You know, and I keep mentioning this, but when we're talking quasi-judicial, citizen complaints, community displeasure are not appropriate criteria for deciding quasi-judicial matters. They're just not. It's appropriate when you're talking about legislative decision-making, but not on these types of matters. And don't base decision. In fact, I was involved about 4 years ago in a case that went up to court where one of the findings supporting denial of a plat application was that they put in, a couple of council members wanted to put in that you know, denial of this plat application is in the best interest of the city and will help further the city's goals of avoiding, you know, more dense development, etc. That got invalidated. We lost that, and they had to go back and pay some attorney fees and go back and redo that whole process. So again, these are not appropriate for quasi-judicial. No politics, and you know, kind of in the theme of everything we're talking about. Don't promise or guarantee or assure results, and this gets back to really, as decision makers, you shouldn't be involved in prejudging anything that comes before you, okay? So don't be making statements, you know, before a quasi-judicial hearing that, well, you know, don't worry about this. We'll make sure that a condition to extend that road does not get included in this decision, or one, you know, an extension requirement does get included. You do not prejudge an application. Don't make those kinds of representations. And this is oops, sorry, hitting the wrong button here. Fat fingers. This one is real, I'm sure frustrating. There we go. Don't let citizens taint the record through comments related, again, I'm emphasizing, quasi-judicial or ministerial applications during open comments or citizen comment sessions of council meetings. And I know this frustrates people no end, but all you're doing is inviting an appearance of fairness challenge and creating all sorts of risk when the application comes before you. If you're allowing citizens to come up and say, you know, we don't want that Walmart, we know there's a Walmart coming in, and I want to get everybody's assurance here on the council that they're not going to vote for this, and you need to nip that in the bud through a strong chair to say, we appreciate that, but you can talk about other things, but that application's pending, it's going to come before us, we don't want to prejudge it, so move on to another topic. You can do it politely, but you shouldn't let the record get tainted, because the more that happens, the more you're creating a record that somebody can say they prejudged this application because of community displeasure or community support or whatever it is. All right, so let me go to what we've been talking about here.
Well, that's kind of a new one. I mean,
Yeah,
Like, I mean, in the
that's-
past, I mean, Pat Anderson in the past used to sort of say, let people vent. I'm not sure how a record gets tainted. I mean, you know, someone got up and testified even during the scoping that said, you shouldn't develop a mill site, it should return to nature and trees and all
Well,
that. And again, it's not relevant to property rights or anything else, they don't really understand that, but,
Okay.
you know, you sort of let them say their piece and.
I'm with you, and far be it for me to second guess poor Pat Anderson. I love him and I love his beer. But I want to be careful. The comment I was making there was tailored specifically to where there's a development application pending. Okay? If people are coming up and just saying, you know, we want to keep our town to be a small town, home feel, and we don't want big box development here, we don't like it. And they're talking as a general policy statement, no problem, let them, that's just fine. I'm not saying don't talk. But I am saying if you've got an application pending for a Walmart and you've got 500 people showing up during the citizen comment period, each with 3 minutes to talk, and they all get up one after another and going, you know, you folks, you're all half you up for re-election here, and you've got a Walmart application pending, it's going before you, you better remember who got you into office. Those kinds of things, that's completely improper, I think. And now, this is where I would defer to Bob on how to handle that, because a lot of cities take it differently. Some cities will say, stop talking, leave the room. I would never recommend that. But what I am saying is, you know, politely have a statement prepared saying, look, we, you know, appreciate your comments and everybody else that's here, but we can't hear citizen comments on that because there's an application pending. It's going to come before us. We don't want to be disqualified, because that's what's ultimately going to happen. Again, it's the catch-22, right? You listen to enough of that, then somebody's going to come in and claim you prejudged it or you were biased in advance because you heard 30 people complain about the very project through a citizen comment period.
So let me clarify. So I think during a hearing for a quasi-judicial process, fine. It's at a regular city council meeting that has nothing to do with that application, where you're saying specific comments, and we had this happen last time, unfortunately.
Sorry, I didn't know that, by the way. I'm not tailoring these comments to stuff that's
So
happened.
during a hearing, on, for example, in a noise ordinance,
Okay.
it would be inappropriate for a member of the community to come up and start talking about a quasi-judicial matter. Is that what you're saying? Within a quasi-judicial hearing, it's fine.
So let me do a hypothetical for you. So if I can paraphrase the guy who came to the council a couple of weeks ago,
Okay.
he would say, don't harsh on Walmart. Okay?
Don't what?
Don't harsh on
Don't
Walmart.
harsh on Walmart.
That's okay up until Walmart makes an application. And from there on, we need to say, and I have a hard time with this too, but your advice is, when he comes up and says, don't harsh on Walmart, you go, thank you very much, but I can't take that testimony out because I'm a quasi-judicial.
Yeah, and exactly. And the way I would tailor that too, and I get it, it's tough, and everybody's looking at me like, hey, you guys are never going to invite me back to talk to you. I know, but that's okay. No,
Could
but
we just go talk to every citizen in Snoqualmie so they
now, hey,
understand
you know
why?
what? If it's any consolation, I've been through this so many times with every other city I've done work for all across the state. This is nothing new. So let me, yes, I would agree with that. And the way I would couch it is to say, look, we appreciate your interest in that. We'll listen to anything else you want to talk about, because there's an application pending before the city that's going to come to us. We want to make that clear, because the point is, it's really doing a disservice to you folks, because you're potentially or very likely going to get disqualified. And then that's the catch-22, right? You've now, because people have come in and made these comments before this group, it's created a potential. I'm not saying it will happen, but it's a good potential that somebody can make an appearance of fairness or bias challenge when the application comes before you, and ask for all of you to recuse yourselves. And then you got a bigger issue to deal with. Then you got to sit down and go, Bob, help me out here. Should I step down? What if I don't? Is this going to invalidate the decision?
Can you cure it with a statement that says, thank you very much, we cannot take that into consideration in quasi decisions, pending or occurring right now, and then included as part of the record for that quasi, that there was this public testimony.
Yes, great
So
point.
I can do it
Yes.
that way.
Yes, and I think putting a statement on the record, just saying, we appreciate, and that's why I think you handle it politely, so that, the citizens don't feel like, you're either kicking us out, they don't wanna listen to us, that's not the issue at all. But then you can also take the next step and say, hey, I see there's a whole bunch of other people here, I assume, how many of you wanna talk about the Walmart? Everybody raise their hand and go, look, it's the same rule, we really can't hear this, and if we do, we're gonna potentially have to step down, you're not gonna have a decision-making body here, is that what you want? You don't have to say it that way, but make
Yes. That's how you contaminate a decision, you actually do that.
Make the point, though, that they're making the comments on this application, again, that's all we're talking about here, is when there's an application, is potentially going to preclude some or all of you from deciding that very application. And that may not be in the groups or whoever's best interest, okay? And that may be a situation, if you're really in that situation and it's frustrating, is to adjourn, talk to your city attorney and maybe get some feedback, maybe Bob's got different advice, because again, I'm giving you kind of the big picture perspective, just because I've seen this over and over and over.
And we have done that in the past. I mean, if there's any kind of uncertainty or Bob feels uncomfortable or Pat in the past, he's kind of said, let's do a timeout, quick executive session. And,
Perfect.
Any discomfort about what questions to ask that you don't want necessarily on the record to throw out there.
Yeah,
Kinda like the one question you don't ask is, can we get sued if we do
Yeah,
that?
Well, I'm giving you some examples, and see, I can say that, because I'm not advising on specific applications, but I'm giving you some examples of where, yes, you could get sued if some of these rules aren't followed, and so, anyway, all right. So, great questions. Okay, so let me real quickly dive into, we've touched on a lot of this. This is arbitrary and capricious. This is a big issue. This is what the standard that underlies quasi-judicial decision-making, okay? Underlies the decision-making. It's a standard of liability. It's not a kind of legal claim, but it's the standard that a judge is going to look at to determine whether your quasi-judicial decision, also applies to ministerial decisions too, is supported or will be invalidated, okay? If the court finds on reviewing your decision and the whole process surrounding it that the decision was arbitrary and capricious, and I'm going to give you very good examples in just a minute, if they make that finding, the decision's invalid. It's of no legal effect and is voided, and you're either going to have to start the whole process over again, have brand new hearings, and a whole bunch of other bad things may happen, may establish a basis for money damages against the city. There's potential personal liability for arbitrary and capricious decision-making, and personal means the decision makers. Time, cost, and embarrassment, and obviously erodes public confidence. So a lot of bad stuff happens if a decision is made arbitrarily and capriciously. So this is what we're trying to avoid, okay? This is what we're trying to avoid, again, only in quasi-judicial decision-making. So here are some examples.